Morning, everyone. The Children and Family Law Committee is now in session. Before we begin the public hearings, is there a motion to move into executive session?
I move to.
I'll second.
So, on Senate Bill 23, is there a motion to be made?
Make a motion not to pass on Senate Bill 23?
I'll second.
Is there any discussion? None. All right. All those in favor say aye.
Aye.
Aye. All those opposed? Motion about to pass passes 3-0. Is there a motion for consent?
Make a motion to go to consent?
Second.
All those in favor say aye.
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 All those opposed say nay. The ayes have it. It's on consent.
And I'll take them out. I'll take it out.
Okay.
If need be.
You can, and Senator Long, you'll take it out. And then Senate Bill 76.
That was, no. Yeah, so I'm going to make a motion to ITL.
Second.
Bill 76.
Is there any discussion?
If I could.
Yes.
Yeah, so this came from, it was sent to the the committee they have set up right now. Senator Hassan was the chair of that commission, and this language was discussed there and accepted. It's an effort for the Office of Child Advocate to be more specific on what it is they can look at and what it is they cannot look at.
You may. So there were some significant concerns raised during the hearing, and I have concerns about the overreach for the 91A and other, that the wording from executive to agency seemed too far-reaching for people to be comfortable with. And speaking to attorneys on that after we left, they were very concerned that would reach out to every vendor that the state uses. So I just don't think this bill is ready. I think there's a lot of work to be done. I think the hearing brought that up, made that very clear.
I agree with the right to know perspective, where it would apply to all records. All right, it's not going to be limited in any meaningful way. I think the law now, I don't think that's housekeeping. I think it's a great expansion to exempt all of the records without exception. I think that goes too far. I also had a problem with the scope, where right now it applies to any child receiving services, also any child that had received services 3 years back. We can debate the 3 years back if we find that appropriate, but it also says anyone who should have received services from the agency, and it wasn't clear who was really making that determination. It seemed that it was kind of this open-ended, where they would have authority in cases where they may have felt it was appropriate, but that child was never receiving any services from them. So I think that this needs basically a complete rewrite of this, I think, is what would be appropriate. Also, there was that issue with the agency and executive part, but that was one, to me, that was even minor compared to the other two. So I'll support the motion of inexpedient to legislate. Any further discussion?
Yeah, I just want to say that the Office of Child Advocate is responsible for, an immense responsibility with respect to children in this state. And I think at the very least, we ought to look at, it appears that there's a couple of issues that I think could be addressed in an amendment.
Well, I think this, as it's written, if an amendment would need to be a complete rewrite. And I think if we started from scratch with something, keep an open mind to it. But again, should have received services from the agency, putting them on. To me, that I understand they may come up with one example where maybe that made sense, but to have that as a general policy, it goes way too far. Okay. And even the right to know side of things, where apparently that's how they're operating, but no one's challenged it. It hasn't been held up by a court. To basically then to have that policy where they can basically decide they want to investigate or look into information on some child that's never been part of their services, on top of everything
Right.
being exempt on the right to know. If you're the parent of that child, I think that they may take issue with that. I think that just goes way too far. I'm not sure if that was the intent of this, but it does.
Okay.
And I think, coming back with a separate bill next year, I'll keep an open mind to it.
Okay.
Any further discussion? All those in favor of the motion of any expedient to legislate, please say aye.
Aye.
Aye. All those opposed?
I'll be opposed.
Okay. The motion passes 2-1. And I'll take this one out. Is there a motion to come out of executive session?
I'll move to,
I'll second it. We are now out of executive session. And we will now open the public hearing on Senate Bill 72. Here to introduce the bill is Senator Kim Lang.
Thank you, Mr. Chair. Senate Bill 72 is a simple bill. It seeks to establish a parental bill of rights in education. The intent of this bill is to establish what constitutes a violation of such rights and proposes a mechanism to notify parents of their rights. Senate Bill 72 reaffirms that parents have the fundamental right and responsibility to direct the upbringing, education, and care of their minor child. Further, no educational institution may withhold information about a child, the child's health, the child's school environment, the child's in-school behavior from the child's parent without a compelling state interest. So the question is, why do we need this bill? So I'm just going to read off all the places in statute that we currently have rights spread over the last decade to 2 decades where we've instituted new laws and stuck them in different chapters, and somehow a non-lawyer parent is supposed to be able to find all of these and understand all of these. We'll start with 189-B:3, and then 193:1, 194-F:1, 193:3, 140-C:20-A, 140-C:20-C, 193-6, 186:11, Roman numeral 9, subletter B, 186:11, Roman numeral 9, subletter C, 189-66, Roman numeral 4, 183-D:4, 126-U:7, 193:3, 186:11, Roman numeral 9-D, 189:65, 189:68, 132:34, 141C-8:18, 193:1-C. And never mind all of those state laws, we also have 20 U.S. Code 1012E, 1114B, 1116E, 1116F, 1111H, 1232H. Those are all the laws that we've spread parental rights across, and somehow a parent is supposed to be able to know where all of that is, as non-lawyers and people who are not, don't necessarily follow it. So what does this bill do? It basically says that the school has a responsibility to put a notice together and give it to the parent at the beginning of each school year. By the way, these are all your rights, and reference all of those laws so we can find it in a single area. Or if a parent is looking, they can just search on parental rights. They will find this new chapter of law, and it'll outline all of the rights that are there. That's what this bill does, right? It establishes those rights to the parents. That right is notice is on page 5, lines 24 and 25. That's really what we're talking about. In the whole bill, everything else is already established in law for the most part. This bill says parents are responsible and have rights, and then lines 23 and 24 require that the school notify the parents of all their rights in a clean, concise manner, both in writing and on their website. That's it. That's the whole bill.
Senator Long?
Thank you, Mr. Chairman. Thank you, Senator. I absolutely agree with you. However, on the school board notification of parental rights, do you believe that there ought to be a consistency with that. I'm sorry, that was page 5 on line 24. Do you think there ought to be consistency throughout the state on telling parents exactly what your rights are? And, you know, as you had mentioned, not in legalese, but in actual language that everybody could understand.
So thank you for the question. So again, if you look under, in the bill, it requires that under 180, I'm sorry, I got to find the section of the bill. So I can give you the page. Again, page 2, starting at line 25, right, parental rights. And it lists all the parental rights in there. And by in that line, it says that the district of their rights is set forth in 189-B:3. So I think it's clear that the school must provide just a list of all those rights we just put under and consolidated under one section, put that on a form and be able to give that to a parent.
Follow if I could?
Recommend.
So 189B6 on page 5, line 24, a listing of all parental rights in the statute is what this is requiring?
Correct. Basically,
Okay.
it sets forth everything that's in section B:3, 189-B:3, which is a list of all the rights that have been consolidated into a single area. It requires the school district basically to list those rights as they're listed in B:3 and give those to the parents.
Okay, thank you.
Senator Sullivan?
Thank you, Mr. Chairman. Thank you for taking my question. Does this in any way expand parental rights?
I'm sorry, say that again?
Does it expand parental rights? Is there anything in there that's not currently in statute?
So there are some components in here. I think that our restatement, that's not necessarily in current law, that talks about, especially when you talk about the findings, right? You go into the first page and we talk about, the parents have a fundamental right and responsibility to direct the upbringing of their child and care of their minor children. We make a clear, concise statement that make for the state. So there are some places where I don't know that's an expansion, but it's a clarification of law.
Follow.
Thank you. You may be aware that there's a lawsuit right now against the Manchester School District for interfering with parental rights. Would this, in the courts, they said there wasn't anything in law that would support them holding up the parental rights. Would this help with that situation?
So again, I think yes, this bill, it makes it clear that schools can't withhold information. We have another bill that's coming forward also, that's my Honesty and Transparency in Education Act, which is just a simple, clear statement that says schools have to be honest. But this bill, yes, I think that if, in any case where a school would violate a parental right that's outlined in this law, it makes it clear and concise for the court.
If I can just ask a question.
I can barely hear
For
you.
the sake of enforceability, what's the remedy under this bill that a parent can seek if they wish to bring an action?
Thank you. Again, so the remedies in here are on page 5. A parent claiming violation or any provision of this chapter may bring an action for declaratory, injunctive relief, and monetary damages against the school, not the teacher, the school, to make it clear, against a district that's withholding the information.
Thank you.
I do have one. Thank you, Mr. Chairman. On that same note, they go after the district. So let's say the district wins. Could the parent sue? So the school district wins, meaning the teacher was wrong in not providing information.
I'm sorry, can you restate your question? I'm not sure I follow it.
Yeah, there's a lawsuit, but a parent brings a lawsuit forward. The district loses. Is there an avenue with which to open up a criminal suit against the teacher? Would you
I
think
don't,
if-
there's no criminal penalties anywhere in here against an individual.
So
So it's a civil remedy, right? So
Right.
it's a civil court remedy, not a criminal court remedy. And again, the parent would bring a civil case against the school district, not the individual, against the school.
correct. And the parent prevails. Would that, in your opinion, would that be an opening for a civil penalty, for a civil suit?
Would that be well, you just brought a civil suit and you won your civil suit, so I'm not sure why you would bring another civil suit.
If I'm the parent and I won my case, that means teacher X was wrong. I'm going to go after teacher X.
Nowhere that I know in this law does it allow a parent to go after a teacher. Again, it's the school
Okay.
itself, right? There's nothing in this law. I don't know if some other section of
right.
law there might be, or some other standing in law there might be. This allows a parent to go after the school district. Remember, there's also an indemnification. There's also a clause in here that does allow them to withhold information, right? If it's in a compelling interest of the state to withhold the information, and it has some requirements around that. So there are cases where a teacher could withhold information, or a school could withhold information and still be within the law.
Right. Okay, thank you.
Seeing no further questions, thank you, Senator, for your testimony. At this time, the chair recognizes Kimberly Allen.
Good morning. I'm Kimberly Allen from Hudson. I'm an educator here in the state of New Hampshire. I hold a few titles here in the state, but the greatest title that I hold is the title of being a mother. I'm here today to express my strong support for Senate Bill 72, which aims to establish a parental Bill of Rights in education. This crucial legislation acknowledges and safeguards the fundamental rights of parents to guide their minor children's upbringing, education, and care. Passing this bill, particularly with an amendment addressing parental rights regarding mental health services, is essential to ensure that schools and educational institutions respect and involve parents in their children's lives. As a parent who has experienced firsthand the negative consequences of schools making decisions without parental consent in my professional and home life, I understand the importance of SB 72. In my case, my son's classes were altered mid-year without my knowledge. They moved him to a class that would help him with organization and help him with his mental health instead of going to gym class. Gym class is far more important than being organized when you're a 13-year-old boy. The school also attempted to provide in-school counseling without my input. Thankfully, I have a strong-willed child who told them, "Did you ask my mother?" And when they didn't have an answer, he said, "No, thank you." Such disregard for parental involvement can significantly impact a child's academic and emotional well-being. Senate Bill 72 will prevent these situations by mandating open and transparent communications between schools and parents, ensuring that parents are informed and involved in major decisions affecting their children. By supporting this bill and amending it to include provisions for parental rights and mental health services, we protect parental rights and create a more collaborative environment for our children's education. The Parental Bill of Rights outlined in SB 72 includes provisions such as the right to access and review all education records relating to a minor child, the right to be promptly notified if a criminal offense has been committed against a minor child, the right to be informed of the school district's discipline policies and procedures, the right to consent in writing before a biometric scan of a child is made, shared, or stored. While these provisions are comprehensive, I propose that SB 72 should be amended to encompass parental rights in cases where a child is assessed or receives mental health services. Parents must be involved in these decisions and have the right to keep sensitive data private. This amendment will assure that SB 72 fully safeguards parental rights and promotes an inclusive, collaborative, and educational environment for our children. I urge you to stand with the parents of New Hampshire, support Senate Bill 72, and advocate for its amendment to include parental rights in mental health services. The future well-being of our children and the strength of our educational system depends on your support.
Thank you for your testimony. If I can inquire with a question.
Sure.
You mentioned, suggested a potential amendment. Do you have language that you wish to offer the committee? to consider?
Not with me, but I would be more than happy to submit it.
If you could email that to the committee, that would be appreciated.
Of course.
And if I could ask another question, you mentioned that your child was receiving counseling or services from the school that you weren't informed of in advance.
I was not informed, and my son declined and said, "You haven't spoke to my mother. I do not need these services." He came home and told me.
So if I can ask, when you found out about this, I'm presuming you followed up with the school.
Yes.
Did the school provide you any explanation why you were not consulted with in advance?
The school kept passing the buck between the assistant principal and the counselor, saying each of them thought that they had spoken to me and that they thought they were okay to move forward.
So the answer is no. Oh, all right.
No.
All right, okay.
Yes,
Thank you.
thank you.
Okay. This time, the chair recognizes Anne Marie Banfield.
I think I have pretty good handwriting, so I'm kind of surprised by that. My name is Anne Marie Banfield, and I'm a parental rights advocate in New Hampshire, primarily focused on excellence in education. So I come here in support of SB 72. However, I would like to point out some areas that I have concerns about. Maybe we can change it, maybe we can mend it, make it better. Parents who struggle to be a voice for their children oftentimes run into lobbying organizations that are well-funded and hire high-priced attorneys to fight against them. I have no financial stake in advocating anything that I've done on behalf of parents. I've never accepted a dime in 20 years. I'm here today because it's the right thing to do. School administrators have taxpayer-funded high-priced legal teams that can be extremely intimidating to parents. The balance of power has always been against parents. I should say always, sometimes balanced against parents. A parental bill of rights would help shift some of that power back to parents. Some of the glaring omissions in this bill is the lack of parental rights to keep a child's personally identifiable information private, and the right to informed consent when administering mental health services in school. Children attending some of New Hampshire's public schools have had their personal mental health data shared with outside organizations like Keene State. This is in violation of the School Counselor's Code of Ethics and our right to privacy guaranteed in the New Hampshire Constitution. School counselors are supposed to protect the privacy of those records, but school administrators are ignoring basic ethical boundaries and informed consent. They are sharing personally identifiable information on a student's mental health with outside organizations. The commissioner's aware of this. Many people are aware of this. This is done without parental or student consent. It is critical that we recognize a parent's right to informed consent on every medical and mental health service or assessment provided to children in school. Blanket consent forms is what they use in school. So a lot of times you're signing something at the beginning of the year for consent on a mental health or medical procedure, and they use that, they exploit that to say, well, now we need to do this assessment, or we need to, bring you into counseling because you signed it at the beginning of the year, having no idea what's coming. So that's a big problem. Teachers have due process, and that same basic right should be afforded to parents when their children attend public school. In the past on these parental rights bills, the constant message from the opponents has been, we can't have parental rights because we have this parent over here. We might have a parent who is abusive. Well, that's interesting because that hasn't been proven in a court of law, but your teachers have due process. That should be afforded to parents. Some of the language in SB 72 includes a laundry list of laws that spell out what our elected representatives agreed should be placed in law. However, are all of these rights or some of these expectations that the legislature agreed upon, for instance, under the right to direct the education of parents' minor child, there is a list of, again, references to bills that have passed, but are those actual rights? Are those expectations? I think that needs to be clarified. For instance, another one is that the right to be advised of any non-academic survey or questionnaire to be administered to a child, and the requirement that the parent consent to a child completing such a survey or questionnaire, as well as the right to opt out of the youth risk behavior survey. So if we're going to put that in law, if we're going to put that in the parental rights bill, this could easily change. So I'm just not sure how some of this is going to work. For instance, right now there's a bill in the House to change the youth risk behavior survey from an opt-out to an opt-in. So that would change this right here. That would change O as it's listed for non-academic surveys. Now, I fully support this. I fully support opt-in. So it's not that I oppose this, it's just this could change, because right now what the schools are doing is unethical. They're surveying all these students with the YRBS without parental consent. That is unethical. This law that I worked on for many years to get passed, I fully supported it. They're invasive surveys. However, this is an expectation based on the fact that it's unethical to give these kinds of surveys. The language affirms the unethical practices occurring in our schools right now. Parents should be consenting on research when it's being conducted on their children. Loopholes exist in federal laws and are exploited. Ethics go ignored, and personal data on children is handed over to ed tech providers and researchers who call themselves evaluators so they can exploit children who have no idea how their personal information is shared. I do want to give you some examples because I think it's important that you understand what is going on in the schools. First of all, I know that Senator Lang, I think, had a question about something aimed at teachers. If a teacher is violating a law, there is a process for that. You file an inquiry with Diana Fenton at the New Hampshire Department of Education, and she investigates it. And their credentials are what's at stake if they are actually breaking the law. So there is a remedy for parents if that is the case. And normally they give the teacher a warning, and then after that they can certainly revoke their credentials. I really pointed to mental health because I think that's the glaring omission in this bill, in this proposed bill. ESSA, Every Student Succeeds Act, does have in federal law a requirement that if you are assessing or servicing a child for mental health, that requires parental consent. You'd be amazed. I mean, one time I went to a hearing, I think it was last year, that the head of the social workers in our schools was so concerned about a bill requiring that. And I sent her an email and I'm like, don't you already know that's federal law? So a parental bill of rights is a good idea because, again, we're going to spell it out. But the only problem is it's not in this bill. So we need to add that ESSA law to this bill so parents know that they have a right. But again, blanket consent is sometimes how they interpret that. So I'm going to give you an example where that's a problem. I had a parent call me and say, you know, my son was playing swords with his friend, plastic knives, and he scraped his friend's arm. And the kid had to go down and get a Band-Aid, and they gave his son a psych evaluation. And his parent called me and said, I never consented to this. So I immediately said, here's an attorney, called the attorney, and the attorney determined at that time that we don't have we can't act on this because there was a blanket consent. Now, could that be litigated in court because you didn't consent to that particular psych evaluation on your son? Possibly. And I want you to keep in mind that these psych evaluations going on in our schools could be used against these kids when they go to, I don't know, sign up for special forces in our military, when they go to apply for a job for a police officer, and a kid's denied because he scraped the arm. I don't know any boys that don't do stuff like that. This is normal boy thing, and he's given a psych evaluation in school, and his parent didn't consent. That's how important it needs to be in this bill, and that's why I'm asking you to amend it. There is no privacy in public education, none. And I have fought to close those loopholes in this state, and the people who fight against this, the unions, the teachers' unions, the ACLU, they are absent. I've made calls to the ACLU, can you come and help me to close some of these loopholes so that we have actual student privacy? Because I'm told that we can't give information to a parent in the Manchester policy. We can't give information to a parent if a child comes in and says, you know, I want to use a different name. Oh, no, it's in policy. They took it to the Supreme Court. They fought every step of the way. But all of that information is shared with vendors, ed tech vendors. All of that information is shared daily without parental consent or parental knowledge. Social emotional learning, all of that information is gathered. So we can share it with anybody, but we can't share it with parents. Isn't that ironic? The fight against parents in the state, especially, I think Manchester's probably our best example of that. It is becoming hostile against parents. They don't have due process. Again, they'll share information, but they won't share it with parents. This is necessary. We need to do something because it's you know, the law firm representing Manchester said, if you don't like it, go somewhere else. That's what they said at the Supreme Court. I was at the Supreme Court that day. I heard what the attorney said. Go somewhere else if you don't like this. And so when the parents leave the school, then everybody complains because now they're using EFAs. And I'm like, well, maybe if you weren't so hostile to parents, maybe they wouldn't be fleeing your school district. Power School is in a lawsuit that you may be aware of because they had a data breach. But what most people don't know is Power School is also in a lawsuit for selling student data. And if you read that lawsuit, which I didn't read it line to line, but it's like 80 pages of what kind of information is going to Power School without parental consent, without parent knowledge, mental health information. So they're in a lawsuit for selling this information. Power School is saying, well, we have the right to share this information. Now, a judge is obviously going to have to determine that, but they do have a point. There is a loophole that allows them to share this information. So you have no idea where all this information is going, but by God, we're not going to tell a parent if their child comes in and changes their name. It's sold on the black market, it's given away, and all this information, no parent has any idea where it's going. The loophole was established in the FERPA, in the FERPA law. There's exceptions so they can share information. But it used to be nothing was shared without parental consent. That loophole, I think, was done in like 2015, 16, around there. I did appreciate that it has a provision about medical care because we are now seeing school-based health clinics coming into our school. And I read the MOU for Manchester and Amoskeag. And again, I wouldn't have signed it. I can't believe the school board allows this because again, there's parental consent language in it, but there needs to be parental consent that needs to spell out every step of the way. And if there's a breach, they're going to tell each other. But I didn't see anything in there about we're going to tell parents if there's a breach. Now, maybe they will, but an MOU should say that parents will be contacted if their child's medical records or mental health records are breached or shared, anything like that. It is so unbelievable what is going on in our schools. So this is a great start. I like it. I'm not going to continue on because I could go all day. But I do appreciate it. I just think that we can do even better with it.
Thank you for your testimony. If I may inquire with a question, you mentioned the suggestion of any amendments. Do you have any suggested language that you could provide the committee?
I'm happy to work with you on that. I think that we need to, you can look at the ESSA language. It's very good. The problem is I think that the schools are exploiting it, saying, well, we don't have to do it for every mental health treatment. I also think that like I said, you're the head of the social workers in New Hampshire said that they didn't want this. But I said, but it's already in federal law. Like, how do you not know? How are you over all the social workers in our school and you are not aware that federal law requires this? That's scary. That's what happens. A lot of times kids come in for counseling, kids come in to the social worker, kids, are sent to the school psychologist, and they're not aware that this law currently exists. But I think the law is good. I just think that it's being exploited not to include every specific mental health assessment, treatment, or service. That makes sense.
Seeing no questions,
Thank you.
thank you for your testimony. At this time, the chair recognizes Deborah Howes.
Okay. Yep, this is still on. Great. Good morning. My name is Deborah Howes. I am the president of the American Federation of Teachers, New Hampshire. And for the record, I am not a high-priced lawyer, but I am here representing our members in pre-K through 12 public education across the state, and we are not taking a position on this bill. We are neutral on it. For the most part, it is a codification of parental rights in education, and a few other things. The education part is what we're focusing on, and it is pretty straightforward. It's things that are already in state law. We do have a few things where we think it should be clarified and could make it a stronger bill. We do have a little bit of concern about some of the framing language that could introduce some questions as to whether it is expanding rights or granting new rights. In particular, page 2, line 27 and 28, where it says the rights of a parent regarding his or her child or children include but are not limited to the following. That is a sweeping statement, and if you're going to then enumerate a whole bunch of state laws that are specific rights, but lead in with that, you are opening it up to vagueness, and that could be a problem down the road. So language like that really does not belong in a law. Also, back on page 1 of the Declaration of Purpose, where, we do acknowledge, of course, that parents have the right to, direct the education of their child. But when you're talking about sending a child to public school, we need to recognize that directing the education of your child cannot conflict with other parents' right to direct the education of their child. So when you're exercising your rights, you can't dictate everything that goes on in the classroom when you're going to conflict with other parents' rights. And you have to either use your opt-out provisions for curriculum, or you have to take your concerns to your local school board and work through their curriculum adoption policies and procedures, or work through their other policies that they adopt, so that you have an orderly process in the public schools so that all stakeholders' voices are heard, and every parent's right to direct their children's education in the public schools have equal balance and weight, as well as the input of professionals who can determine the value of the curriculum. Because you may have a deep-held belief that 2 + 2 is 5, but I want the engineer who's building the bridge to know that 2 + 2 is really 4. One more thing we have a concern about is, and I'm going to find the right place before I mention it, on page 5, line 4, to me it appears where it says no school or school personnel shall infringe upon any of the parental rights set forth in RSA 189b3 unless the infringement is supported by clear and convincing evidence and is narrowly tailored. That seems to create confusion over mandatory reporting. The standard we have now in RSA 169c29, mandated reporters have to report anytime there is reason to suspect. And the reason we do that is because we are not investigators. If you see something that makes you suspect a child is being abused or neglected, we are trained that you need to report it and let people whose job it is to investigate figure out whether there's validity to it or not. Okay, they actually tell us that we are not supposed to investigate because you don't want to do anything that might suggest something to a child and maybe get in the way of a good investigation happening. So you don't want to taint an investigation. If you see something, you follow the correct chain of reporting and let trained investigators do their jobs. Our job is to do our best to make sure kids are safe. So we just don't want confusion with a different standard here. I request you take those concerns into consideration. You can make this a stronger bill. We really think that parental rights in one place would be helpful, so there would be less contention around what parents have a right to, and everyone would know exactly what needs to be reported, and it could really lower the temperature and make for more fruitful collaborations and less arguing over it. So that's what I have to say. Thank you.
I'm going to inquire with the question. The last issue you raised
Yep.
had to do with as page 5, lines 3 through 5, where it said clear and convincing evidence. Are you interpreting that the reporting requirement, let's say, as a mandated reporter would change? I'm not sure I understand.
I'm getting an echo, so I'm having a little bit of trouble understanding your question.
So you interpreted that, I understood your testimony, that you believe that section would change the burden on a mandated reporter?
My reading of that is that it could create confusion over the standard for mandated reporting, yes. That was my understanding of that. If that was not the intention, then can we make it clearer that that's not the intention?
So when you read that, because I understood that section to be if they're going to withhold information from a parent,
Yep.
that's the burden they would have to cover, clear and convincing evidence. That's a common evidentiary standard, where I think the mandating reporting requirements is completely different. So if they would withhold information from a parent or not comply with any of the parental rights set forth in this bill, that's the standard they would have to reach. But I don't believe why would you believe that impacts mandated reporting requirements?
Well, the two would be tied together in my mind, that the reason you might be not disclosing something to a parent is because you suspect there is something dangerous to the child going on. Because otherwise you would be seeking to have open and clear communication at all times, obviously.
Thank you.
Yep.
See no further questions. Thank you for your testimony. At this time, the chair recognizes Susan Stevens.
Without killing myself on the cords. Hi, Susan Stevens, I'm from Samberton. Tim, I had a hard time understanding, where'd he go? Anyway, I had a hard time understanding a lot of what Tim was saying because I'm hard of hearing. And also, if you guys could speak a little slower, I had trouble understanding you guys also. It's not a volume problem, it's a different kind of problem, and I don't need an interpreter, so don't worry about that. I just want to say that I fundamentally oppose this bill for a couple of reasons. And this is my first time speaking at a State House, so I'm not terribly organized. I've been just taking notes. When I first read it, I was horrified for a couple of reasons. I think at the very least, I agree, it needs a whole lot more discussion to make it a stronger bill. People have already said, like the last speaker who said on page 5, the lines 3 through 5, that leaves it open for a lot of things. There are kids like your kid who came home and said, gee, Mom, they want me to do this. And you say, okay, let's talk to the teacher. And yeah, there's a little bit of a problem. Some teachers don't want to, oh, I thought they called. No, I thought they called. Well, that's a different problem because your kid talks to you, okay? There are a lot of kids who are in crisis that can't talk to their parents because they go home and they say, oh, Dad, I'm gay. And they get beat up, okay? Or they get sent away to some reprogramming school. And I know that's a very specific example, and I use it because it's an extreme example. But there are other reasons that kids don't want to talk to their parents. Their parents may be perfectly wonderful people who fundamentally disagree with some of the things that the kids are thinking up. They're independent beings. They have agency. And, you know, there's other, the bill, Tim was saying that that all these things are in other places, in other laws. Well, what's going to happen to those? So if this little piece was in SB 77 in 2012, well, who's going to go back and take those out, saying this has been replaced by such and such a thing? So then do you get conflicting bills where this one gets a little bit tweaked and now it's different than the previous one? I don't know. I don't know that. And then there's a provision in here about you can go to a private school if you want to. Does that mean my tax dollars are going to go pay for some charter school? That's not private education. We're guaranteed a good public school system here. I don't want my tax dollars going to a private school. Or okay, the people who are rich enough pull their kids out anyway, and they still get the money for these charter schools? No, that doesn't make any sense to me. So I think, in general, this doesn't look so bad, but it needs a whole lot more discussion. And I did have another comment, because I didn't really know what Power School is. The policy of Power School, they don't directly share student data. It may say that, but maybe that's something that needs more oversight. Not saying parents need to be informed every time their kid gets, a scratch on the arm. I think the stuff that happens when you're a minor doesn't necessarily show up if you want to apply to the military. I'm not sure about that. But I think it's not a bad idea, but there's no place in here for the Student Bill of Rights. I mean, HIPAA, you can't, if your doctor finds that you're being abused by somebody, your doctor doesn't have to tell the parents. That's a HIPAA rule. It's a federal thing. So I think that more discussion maybe before you just pass this thing, because there's a whole lot in here that I think most people I can't understand half of it. And I'm an engineer by training, so I can understand a lot of really complex things, but these things are very, some of them are pretty esoteric. That's all I wanted to say, is that I'm not saying this is a horrible bill. I just think it needs a whole lot more discussion before it gets passed, because there's questions in here that are just not necessarily good for all the students. And teachers' jobs are not to tattle on kids. Kid wants to use a different name. Okay, some kids think they're tigers. They're kids. So why does a teacher have to go talk to the parent every time something like that happens? What happened to teacher-parent conferences? What happened to the PTA? What happened to all those things? Why are those not good vehicles? Why are you requiring teachers to tattle on students for whatever? I just don't get it. So, thank you.
I can just inquire with the question, and I'll speak slower. I do my best. If I go too fast, just put your hand up.
Okay.
So I understand, the issue with teachers. You don't want them tattling on, the student. I mean, I think that teacher informing the parent, I don't know if that's the same as tattling, but I guess my question to you is, if a parent were to specifically inquire to a teacher about their child, who's their student, don't you think the teacher has an obligation to be honest and straightforward with that parent in response? I mean, at the parent-teacher conference, if they ask a question, shouldn't they answer it honestly?
Absolutely. But I don't think that has to be written into law. I mean, I think that if you don't have that relationship with the teachers, there's a different problem. Or the kid has said, please don't tell my dad, he'll kill me. And there's a whole bunch of reasons, like if your best friend came and told you he's having an affair with somebody and said, don't tell my wife, and the wife comes to you and says, gee, is he having an affair? You're going to be conflicted. And I think that in our society, codifying laws to require people to disclose information just makes everybody hostile to each other. I mean, I think that there's a lot of other problems that we probably can get through that if what we do is actually talk to each other. If you don't want your kid learning about giraffe behavior, then you can opt out of those things, and the kid won't learn about giraffe behavior, whatever it is, but have the conversations directly. Don't legislate this stuff. It just makes everybody afraid. Can I talk to this parent? Can I talk to this teacher? What is my kid saying? Am I going to get arrested for talking about giraffes to this kid? It just makes education impossible, or very, very difficult. And I think the problem is not the conversations between the parents and the teachers and all that stuff. The problem is, what are we putting in these curriculums that's really so harmful? knowledge is power. The more we can teach these kids about everything, they go home and they talk to their parents about, gee, I learned about giraffes. Then yes. And then the parent has the opportunity to say, ugh, giraffes are horrible. Or don't be gay, or whatever they're going to say. But all these questions that come up, if you have a good relationship with your kid and a good relationship with the teacher in the school system, those conversations are going to come out. You know, if your kid's afraid to talk to you about whatever it is, giraffes or whatever, then of course there's going to be difficulty. But you start legislating that, and teachers then get to be afraid, and then you have, well, oh, so-and-so is talking about giraffes, and then it gets all around, and it just creates this hostile environment, not a learning environment.
Senator Sullivan?
Thank you. Thank you for taking my question, and thank you for being here. I know it's not easy to speak. We still get nervous when we have to do it, so I really do appreciate it. If it's okay, I just wanted to clarify a couple of things that you said, if you don't mind. Maybe you'd understand the impetus for the bill a little bit. So Manchester School District actually has a policy in place that was put in by the school board that states that teachers do not have to share information with parents. That was part of the impetus for this bill to come forward, because it did create a lawsuit, a lot of hostility in the school, and parents, the PTA you mentioned, feel like they're no longer accepted or welcomed into their child's education because of some of the policies that are happening. So this is actually an attempt to open the door of communication between parents and teachers. Another couple of things, I just wanted to let you know that our charter schools are actually public schools. They're not private schools. You'd mentioned charter schools and sort of intertwined them with private schools. And the other thing was that the power schools actually just did have a huge data breach, and children's their information was exposed.
Sorry, but Facebook has data breaches. You got Elon Musk reading everybody's...
These are the examples you brought forward, so I just wanted to bring some clarification for those.
Yes.
Thank you.
Yeah, so I would say, in response to the Manchester Public School District School Committee, that the problem is not a statewide problem, then it's a Manchester problem. I mean, if you're getting people on your school board that are putting forth policies that are not okay with the Manchester's people, then the Manchester people need to look locally at what the problem is. Don't mandate what happens in Samberton or Exeter or wherever, because if that policy's there, it may not be everywhere. And putting this stuff in just creates this hostile environment. The teachers in, Carroll, New Hampshire may very well have great relations with their parents, and then one parent decides that they want to say that there's a problem. You get lawsuits, and who's going to pay for all those? Who pays for those if a school district gets sued for something? I don't know that. I mean, that just seems like it's just creating a whole can of worms. If you don't like your school board, fire the school board, or get people you like better on the school board that don't make laws that are egregious to the parents, And just, even if the school board says they don't have to share, doesn't mean that they won't share. I don't know. I'm not in Manchester, I can't say, but it just seems to me it's creating there's a lot in here that's very interesting, and yes, I think that parents should be involved and need to be involved, but I think this whole bill needs a whole lot more discussion before it gets ratified or even voted on.
I see no further questions. Thank you for your testimony. The chair recognizes Brian Hawkins.
Thank you, Mr. Chairman. Figured I'd get up process of elimination. I was the last one to speak. My name is Brian Hawkins, for the record, NEA New Hampshire. Thank you for hearing my testimony. I'll try not to duplicate what's already been said. I would just first appreciate the fact that it is important to communicate these statutory rights out to parents. In fact, in a previous iteration of this bill, we had supported an amendment that would have done just that. Secondly, we would respectfully first agree with what President Howes said regarding the page 5 page 5 lines 3 through 5, we do have I'll hand in some written testimony. We do have some suggested alternative language there. Thirdly, also echoing the questions around some of the parental rights that look to be potentially an expansion. That's A and B, the right to direct the upbringing and moral or religious training of his or her minor child. This seems a little vague to us. What's included in moral training? There are morals that schools teach all the time, but how they teach them cannot necessarily be directed for each individual student. And then also on B, the right to direct the education.
I don't mean to interrupt you, but I am. But if you're referencing a specific section of the bill, can you tell us the page?
Oh, I'm sorry, yes. So under proposed 189B3, this is the list of parental rights that starts on page 2. And I'm referencing specifically letter A, which is on line 29 and 30, and B, which is 31 through 34. My apologies. So, so the question with B being, how does this interact with the rights of other parents to do the same, and what happens if there are parents of children in the same classroom who disagree about the direction of the classroom instruction, and which direction that should take. As was mentioned earlier, there is the current opt-out laws that are already there. And then on page 4, line 14 through 17, there's a paragraph referencing children fundamental rights. I think this, as far as we could tell, is new. And so the concern here is that is how this is a similar component, that this is somewhat vague. So if a student swears in class or disruptive, disciplined by a teacher, does the free speech apply to that particular situation? I don't think that's what you probably intended, but I think some clarity would be important there. If a student needs to be redirected, I don't think that is what the author probably intended here. And the suggestion here would be that later on in the bill they outline what the bill does not do, and so there could be some clarity put in that section of the bill to clarify that. And so, like I said, I do have some written testimony. I hope you'll take a look at it, and we appreciate the committee's time and consideration with our concerns. Thank you.
Thank you for your testimony. If I could inquire, you're saying freedom of speech is vague. My understanding, the forms and types of speech that are protected under the First Amendment has been well defined by the Supreme Court of the United States.
Yep.
So swearing has never been a form of protected speech.
Yeah, I think we were just looking for some clarity there, Mr. Chairman.
Where is the confusion there? I mean, if using four-letter words is not protected speech, why would you believe that would apply here?
Well, currently there, as you said, when you walk into a school building, when you are in public, there are limitations on free speech, and so again, we're just looking to make sure that that's not conflicting with the ability of an educator to follow school policy and procedure when it comes to those situations.
Is the freedom of speech section the only part that you think is vague in that section? It's page 4, lines 14 to 17.
Those were examples. I think that, as I said, one way to just create some clarity here would be to highlight specifically, what the bill is not trying to do in this situation, which the bill does do that with several instances near the end, and that would be one alternative we would just ask the committee to take a look at before you finalize the bill.
And you suggested that there was, you agree with prior testimony on page 5, lines 3 through 5, that part is also vague, or could you some clarification? What about that section do you find confusing or vague? Because I know the prior testimony was referencing a mandated reporter. The line above it is pretty clear to me, prohibits requiring disclosure as a mandated reporter or otherwise required by the law. So I feel like that's already addressed in here, saying the mandated reporting requirement is not changed. So what's confusing there? I look at that as that's the evidentiary standard that would apply if there's a violation of this bill, which I think it's good to spell that out when you're creating legislation. That's not the lowest burden of proof we could have put in there. Could say preponderance of the evidence. You put clear and convincing evidence, which is a higher burden.
So I'm not so sure I would say that sentence, I'm sorry, you were saying page 5, lines 3 through 5. Okay. That it's vague. It is that I think that particular line, we have a suggestion on how that could be. Some of the rights previously stated in the bill looked vague, and so that one of our suggestions would be that no school or school personnel shall knowingly infringe on parental rights, because if there is a broad right there that may not be clear to an educator, it'd be important to I think clarify that or give some kind of qualification there that somebody was not knowingly or trying to infringe on a particular right that was named. So a couple of suggestions in my written testimony for that.
Seeing no questions, thank you for your testimony. Are there any members of the public? Oh, we have some more. At this time, the chair recognizes David Trumbull. You can approach.
Thank you, Mr. Chairman. Good morning. My name is David Trumbull. I'm from the town of Ware, and I oppose this bill for 2 reasons, and they were both addressed when Senator Lane gave his testimony. The question was, does this expand parental rights? And he said largely no, but in 2 areas, yes. First, it makes parental rights a fundamental right, and second, that schools cannot withhold any information from a parent, and that's both in the purposes sections of the statute. So I'd like to address both of those. I'll use example of a child who is gay, who talks with their teacher and says, I'm gay, my mom understands, my dad will lose it and throw me out. How should I go about negotiating this at home? If that situation arises. So the 2 objections I have to the bill is first, that children should have a voice in making choices about their own lives. Now, the Manchester case, Doe versus Manchester, went to the New Hampshire Supreme Court. They decided it on August 30th of this past year. It was about whether or not schools should be forced to reveal a student's LGBTQ status to their parents. The court said in its decision that they're basing the decision solely on the New Hampshire Constitution. They looked at other federal courts for information, but they were making the decision solely based on the New Hampshire Constitution. The court said that while the parents' right to raise their children extends to the public school setting, quote, it is not an unqualified right. They then went on to say that the Manchester school policy places no limits on the plaintiff's ability to parent her child as she sees fit. And the court went on then to say that parents have a self-help remedy, talking with your own children, listening to your children. Don't yell at them and threaten to throw them out of the house. Actually, talk with them. And they went through a whole list of examples of how parents can talk with their children. It's clear that a parent who supports their child who is gay would not need this bill because they can talk to their children already. The bill creates a legal framework in situations involving schools' duty to report that gives parents 100% of the rights and their children 0% of the rights. Now, when a child is a baby through age 6 or 7, the parent has 100% of the power and needs to have. But as children grow up and hit 13 and then 16 and 17, they start having a personhood of their own, a personality. They start to have the right to make decisions about their own life. Obviously, you look at the divorce cases in this state. New Hampshire Supreme Court on at least 3 different occasions has said that once a child hits the age of 13, their decision is important in how the court will make its decision because they are capable. And sometimes that's choosing parent 1 against parent 2. I think that children should have the right to talk to a teacher about something personal without their parent having the right to know everything that was said in those conversations. I agree with the New Hampshire Supreme Court. The parent's right is a fundamental right, but not an unqualified fundamental right. This bill would make it an unqualified fundamental right. The second issue is the role of schools. Schools are right now a safe place where a child can talk to a teacher or any trusted adult. Unfortunately, for many LGBTQ children, home is not a safe place. 14% of LGBTQ youth report having slept away from their parents because they were kicked out or abandoned. 40% of them just because they were LGBTQ, and that's from the Trevor report. School, however, can be a safe place for many LGBTQ youth. Having one trusted adult significantly benefits the mental health of children, reducing suicide attempts by 40%, also from the Trevor Project. This bill makes it impossible for a teacher to continue to be that trusted adult because the exceptions clause to this bill, the one that's got a lot of attention on page 5, lines 3 through 5, is impossible for a school to meet. It lays out the compelling state interest test, requires that schools provide clear and convincing evidence that a future event of abuse or neglect is quote unquote likely to happen and that the action is narrowly tailored. That's, in lawyer talk, the strict scrutiny test. That standard was rejected by the New Hampshire Supreme Court in Doe versus Manchester. They held that because the parent's right is not an unqualified right, the strict scrutiny test is not appropriate. That means the compelling state interest test is not appropriate. The narrowly tailored standard is not appropriate, and the clear and convincing evidence standard is not appropriate. Instead, the New Hampshire Supreme Court, basing its decision entirely on the New Hampshire Constitution, said we should just use the rational basis test, which only uses the preponderance of evidence standard. I think schools should be allowed to use their best judgment using the preponderance of evidence to determine whether or not to tell a child's parents about their LGBTQ status. Thank you very much.
Senator Sullivan with the question.
Thank you, Mr. Chairman. Thank you for taking my question. What you just used as an example was the Manchester case yet again, and I do have permission from the family to speak on this case. They are very loving, caring people that took very good care of their child and had an open relationship with them. The child was going through a very difficult time, and it was a cry for help, what was the behaviors in the school. The parent reached out to the school because they were concerned about their child. And if the parent didn't continue to dig outside of there, that child would have been a casualty in our society.
I'm sorry, it's hard to hear you.
The child would have been a casualty. Do you understand what I'm saying? So, you really, is that better? I talk loud anyway, so I'm sure the echo is not helping. So that child would have been a casualty had the parent not continued to dig. The child was never LGBTQ. The child ended up in a public charter school where they were thriving and healthy and happy. So I just want to put aside this idea that parents, especially in this case, were abusive somehow or did not have a relationship with their child where the child felt like they could talk to them, but sometimes kids need a little bit of help to get to that place, right? So I don't think we can just say that all parents are abusive so we can't have this law, which is what it continues to come back to.
I can't say that all parents, it's hard to hear you. All parents what?
The reason that people keep using to put this law down is because they think that parents are inherently abusive to their children. And I think we need to dispel that and talk about the fact that most parents have come to us for this because they want to be better partners with school, with education. Would you agree that this could open up pathways so that parents can be better able to have closer relationships with the teachers and benefit the children in the long run?
I do understand that, and I was not suggesting that every parent is abusive of their children, and nor that the Manchester regulation prohibited schools from talking to parents. What the Supreme Court of New Hampshire said was that we shouldn't have a rule that every teacher is required in every single case to tell the parents. And that's what this bill does. It creates a 100% totally right that can never be exempted because the standard to meet, the evidentiary standard, would be impossible to meet. So I can understand where there are parents who are trying to work it through with their child. They don't know, their child is going through teenagerhood, and they may not realize that their child is gay, or the child is working this out for themselves. So I'm not attacking parents. What I'm saying is you are writing a law that will be in effect for every single child in the state, every single parent in the state, every teacher in the state, every school in the state. And the New Hampshire Supreme Court said, based on Constitution, that it should not be 100% strict scrutiny, that it is always going to be states have to tell the parents everything they know in every single situation. And that's what Senator Lang said, is that the purpose of the bill was to create a situation where a school can never withhold anything from a parent. And the Supreme Court said that's going too far. So I'm not attacking any parents. What I'm saying is this bill goes too far. There are potential changes to page 5, lines 3 through 5, that would still allow parents that have that good communication with the school, which is what we want, because it's a team relationship, parent, child, and school all working together. But this bill goes too far. Why not? I have a proposed set of words for you. One sec. Instead of saying by clear and convincing evidence using the compelling state interest test, why not just say the best judgment of the school using the preponderance of the evidence? So the school will use its judgment in determining, in this case, this is not a good case to tell the parent, because if I do, that parent may throw this child out onto the street. It's February, it's cold, it's snowing. This would be the case where let the teacher use their judgment in that case, because the parent still has self-help remedies. They can still talk to their child. They can do all kinds of things to find out on their own. This is just, you're making a law that says if a student talks to a teacher, trusts that teacher, tells them something, and the parent wants to know, what did my child tell you in a conversation, the teacher would have to answer that parent in every single situation. That's the problem with this law. As it goes too far, it means that a teacher can no longer be a trusted adult, because they're going to say to the student, don't talk to me, because anything you say to me, I'm going to have to repeat to your parents. And that trusted adult is important.
If I can inquire with a question, and please let me know if you're having trouble hearing me. You're saying in every single circumstance, without exception, that the teacher would have to make a disclosure. I'm understanding, I read on page 5, it's lines 13 to 23. I interpret that as it describes a circumstance where the disclosure would not be made, and it sets forth a procedure that would have to be followed when that disclosure is not being made. So I'm not sure if you read through that section of this bill or not, but
yes,
it seems that that's an exception to when they wouldn't make a disclosure. So I don't think it's universal, but if you...
Can you give me an example of when a teacher under this bill would not have to tell a parent something?
Well, I think one obvious example would be if they're a mandated reporter, the identity of the mandated reporter would remain confidential.
Okay, the
So
name of the reporter.
even though the teacher may actually know who it is, who the mandated reporter is. I mean, the teacher themselves is also a mandated reporter, but they may not have been the one who filed the complaint or made the report. But in that case, I think it's pretty clear they would withhold that information, and I think that's covered in this bill pretty clearly.
Okay, that's fine. I was asking, is there an example where, when it comes to identity of a child as LGBTQ, where the student would not have to tell the parent, the child has addressed us, and this is what they've told us? Is there any situation in this bill where the school would not have to tell that child?
Yes,
I mean,
there is.
that parent.
And I think you need, if you want specifics, they would have to be a reason why they're not making the disclosure, not simply because they don't want to disclose the gender identity. I don't think that they can just say, we don't want to disclose it. If there's a reason they fear for the child's safety, I think it's pretty clear. If they would have to put forth some facts explaining why, they can't just draw that conclusion arbitrarily.
You're right, but the law, as worded, says the school can only not tell if they have clear and convincing evidence that abuse and neglect in the future is likely to happen. That's an impossible. The only way you could know that with clear and convincing evidence of that level of certainty would be if it had already happened in the past, if the parent had already abused the child or thrown them out once before or something like that. But there's no way you could rise to that level of certainty about a future event.
I understand I'm not sure I agree with you, but I understand your answer, sir.
All right, thank you.
Senator Long?
Thank you, Mr. Chairman. So just for clarity, in the 3 to 5, instead of clear and convincing evidence, which I agree with you would be difficult for a teacher or a janitor to figure that out. First of all, they're not trained in clear and convincing evidence. If they were to use the preponderance of the evidence, that would make it easier for a non-attorney to know exactly what the meaning is in there.
Thank you, Senator, for the question. And that's exactly right. If you take out the words clear and convincing evidence and replace it with preponderance of the evidence, cross out narrowly tailored, and instead of using compelling state interest, use the rational basis standard. That's what the Supreme Court did in the Doe versus Manchester case. What this law does is says to the Supreme Court, we don't agree with your analysis of the Constitution. We're taking out rational basis, putting in compelling state interest. We're taking out preponderance of evidence, putting in clear and convincing evidence. The Supreme Court already ruled on this, and they told you under the Constitution what standard to use. So I just think if you change page 5, lines 3 through 5, and go with what the Supreme Court said, then it would not, otherwise it's going to be subject to another challenge. So why not just, they already answered this exact question once. It still allows parents to talk to the teachers. It just lowers the level of proof that has to be required.
Thank you.
I see no further questions. Thank you for your testimony.
Can I have testimony?
This time the chair recognizes Courtney Tanner.
I think I get the privilege of being last. Sorry, Brian. Good morning. Is it still morning? Courtney Tanner. I am the Senior Director of Government Relations for Dartmouth Health. You've heard a lot of testimony this morning about standards, and Senator Abbas, I think you're well positioned as an attorney to start thinking about those. I want to raise up a couple other, I want to underscore some of the testimony that has been shared and talked about relative to standards, and talk about a couple of other pieces of the bill that just want to, I think the bill needs a little bit more work. I understand that there's a lot of energy behind the bill to move it forward. But in addition to the testimony that you just heard around preponderance of the evidence, just want to underscore that I think that would help us to get some of the other pieces of this bill in alignment with some other state statutes and federal statutes, particularly as we look at the medical pieces of the bill. So I want to draw your attention to page 3. And down by the bottom lines 34, there is a provision in here relative to access to medical records. I can provide suggested verbiage for this section of the bill, but I don't think that this bill is covering all of the pieces that really need to be contemplated relative to access to medical records, particularly federal standards. HIPAA has a different standard, which is really a reasonable person standard, a professional reasonable person standard. So that should be contemplated and aligned in this state statute as well. Additionally, there are other provisions in federal law that protect vulnerable populations. For example, 42 CFR Part 2 is a federal regulation that protects the privacy of individuals seeking substance use treatment, including persons who are 12 and older. And so we need to be thinking about that too. Additionally, I want to draw your attention to page 4, lines 11. This is relative to the right to be informed and provide consent to medical procedures, but there are certain procedures that are not contemplated in the bill as drafted. For example, sexually transmitted diseases. Here in New Hampshire, substance use disorder treatment and sexually transmitted diseases, individuals who are 12 and older have access to that level of that type of care, have access to medical care without consent, parental consent. And so while we at Dartmouth Health certainly always encourage and champion parental involvement, whether that's access to medical care outside of schools or in schools, we just need to make sure that access to care for persons who are 12 years old and older are protected as already contemplated in state and federal statutes. I'm happy to take questions. I'm also happy to continue to work with the committee to ensure that these provisions are contemplated. But I also, and I'll just summarize that, I also think it would be helpful on page 5, as was just testified on, so I'm not going to beat a dead horse, but it would be changing the standard would ensure that there was direct alignment with state and federal statutes. I'm happy to take questions, but I also appreciate I'm your last one.
If I could ask, you mentioned, I'm referencing page 4, lines 11 to 13, and you suggested that we should add provisions for substance abuse and sexually transmitted diseases. Are schools, if I'm ignorant on this, I apologize, are schools actually treating students for sexually transmitted diseases?
I represent Dartmouth Health. I don't represent schools, so I can't speak to that.
Thank you. Senator Long?
Thank you for your testimony. I mean, I've been thinking of, I know some states train in what's required, parental rights. Would you have an opinion on that, of whether there should be some training to school personnel on?
I don't represent school center, so I can't comment on that. If you want to cover up my badge, I'm a mom
Yeah.
of 2 girls, and I think, clear communication is always very helpful.
Okay, thank you.
Thank you, Senators.
Seeing no questions, thank you for your testimony. Are there any members of the public who wish to testify that have not testified already? And is there anyone in the anteroom? I'm going to give it 10 seconds before I... I'll say it one more time. Any members of the public who wish to testify that are here that have not testified already? Seeing none, we will now close the public hearing on Senate Bill 72. And just so that everyone knows, we may open the executive session. We're not going to exec this in its totality today. As we discussed last hearing, there's some right-to-know issues because my colleague and I, if we were to have a private conversation, it would be a quorum. So we're going to talk now, so we may go into executive. I won't be recognizing anyone for a motion.
So I'll move to open executive.
That's been seconded. We're now in an executive session, so we can discuss Senate Bill 72. Again, we're not going to move this for a vote on anything today. Any comments from anyone?
Yeah, I just think the clear and convincing evidence is something that we need to look at. And I know you were addressing some issues as an attorney, you would know that. But there were 2 non-attorneys that had concerns with that same area with clear. So I don't know if that's, after listening to you, I got it, but I don't know if they'll all.
Just to address that, so I think the way it's set up, that if a teacher believes that they has hit a threshold where they can infringe on the parental rights, all right, they have to then demonstrate to their superior clear and articulable facts. So they have to basically state their case to their superior. All right, I think it would be smart, regardless of what it says, whether it's preponderance of the evidence or clear and convincing evidence, that they still discuss it with their own legal counsel. If they choose not to, they don't have to. I understand one's higher than the other, at least on meeting the threshold of meeting your burden to do it. But it's done with consultation. I don't think, if someone doesn't understand what clear and convincing evidence is, it doesn't seem to me they'll understand what preponderance of the evidence is, right? Those are just evidentiary standards, and I guess on the pecking order, preponderance of the evidence, it's not this exact same, but it's parallel to the probable cause. It's kind of a more likely than not standard. Preponderance is higher, and then, beyond a reasonable doubt is the highest there is for a burden of proof. So it's kind of in that middle. I think that clear and convincing evidence is used in a lot of different areas of law. So for someone to say, I have no idea what this is, I can't figure it out, it is throughout RSAs everywhere, as is preponderance of the evidence. So if they don't want to consult with their legal counsel and explain to them, this is what we have, this is the information we got, they can get a recommendation on that, on how to go forward. I think either way, they should be doing that, whether we change the burden or not. I suppose they can rely on less articulable facts than if it's lower, but I think they want to rely on all the best information they have. But I understand the reason why they may want to change it, maybe consistency-wise.
Right.
Nothing in this overrides mandatory reporting. Nothing. So they're still mandatory reporters. If they think bringing any information to a parent is going to endanger a child, they're obligated to report that. So I'm not really sure about where the concern is.
Not only are you right, if a parent says,
Happens once in a while.
if you continue to do this, I'm gonna throw you out of the house. I mean, I think that meets the neglect standard.
100%.
Right, so right off the bat, I think that would invoke,
Yeah.
throwing out any child that's a minor, kicking them out of your house when you're the parent or guardian of that child is,
Yes.
I think that's neglect, and I think it can easily rise to abuse.
So, I also, the same arguments come forward every time this bill comes forward. It seems to be that the parents are vilified, and there isn't a teacher in the world that would possibly harm a child, right? And we know that that's just not true. There's good people in all things and bad people in all things, right? And we've seen some of this come to light with children that confided in a teacher, and a teacher used that to sort of gain the confidence of a child and hurt them. So I think that you have to be cautious on both sides of it, but I do think mandatory reporting is still relevant. It's not watered down by this at all.
Yeah, and with respect to, if somebody was to kick their kid out of the house, that has happened. And who's gonna argue that, the kid? And the kids that I know that are living with somebody else whose parents have thrown them out, the kids don't bring their parents to court. They're embarrassed about them getting thrown out of their parents' house. I don't want nobody to be talking about this. So I'm living with Madam X, and we're keeping this quiet. So I agree with you that it is a violation, and you can go after the parents. But nobody does of the people that I have known that have got thrown out of their home.
So first of all,
17.
that's wrong, that parent was wrong to throw
I
a
agree.
minor out of the house.
I agree.
Because, so leave it at that. But if that parent who now thrown their child out of the house then wants to inquire about information in the school, it seems contradictory that they
Right.
kick their kid out of their house and then want to inquire in the school and get it and now be involved, and they chose not to be. But even if that did happen, if the child says that my family threw me out of the house, one, that would invoke the mandated reporting requirement, so the teacher should not, they should make that disclosure. But two, I think that's a compelling interest why they wouldn't tell the parent more information. They already kicked the child out of the house.
Yeah.
I think they would meet that burden, and I think they would meet that under both the clear and convincing and the preponderance. And they always can talk to whatever household took that child in. If they were to talk to that family or whoever's run that house, they could, I guess, second or corroborate the information they got. I don't have a problem if that's how the school reacts in that situation. The parents threw the kid out of the house. I think what's happening is this isn't happening in the school district that I live in, which I'm very happy about. I'm not getting any complaints about this, but what I hear in Manchester, and I know you.
Yeah, I'm not hearing the same thing.
I'm surrounded by Manchester on both sides here.
So once Manchester
going
had
on?
their policy, it wasn't just Manchester, it extended to other schools across the state. And we actually had one of the members of the House that supported this last year, who is a member of the transgender community. that supported some of the language in this. I reached out to them to figure out how we could change the Manchester policy, because they were supportive. And so it did start to spread, and that's why it escalated to the state level, right? To sort of put the brakes on this so that parents, before it's everywhere, right? It did start to spread, and to just codify the parental rights. But the Supreme Court ruling also was one of the reasons. They said there was nothing in statute that they could use to support the parents. So having this in statute gives them that piece.
You know, and I also have issues with divorced parents. Well, with divorced parents. I mean, you know, they both have full custody. You know, I don't want my ex-wife to sign them up for football. She signs them up for football. I mean, I get that in from, you know, because when I have custody, I do what I want. When she has custody, she does what she wants. So I see an issue with divorced parents on gathering information, even though they're not being investigated on anything they've done wrong. It's just, I'm gonna know information, you know, I thought you told me you weren't gonna sign up for football. You know,
That's not the school's fault, though. I mean, in the most parenting plans, whether it's a court order agreed upon, should address extracurricular activities
Right.
and
Right.
legal custody. They should, and that doesn't mean they do. So there are some that won't.
no, right.
But the school in that case didn't do anything wrong. That's just the parents that need to.
No, I agree with that. However, it sets up parents to be able to, I sitting on children and family law for 18 years. Give me a reason where I could take my ex to court and I'll grab it. You know, that's minor in this. First of all, I agree with the declaration of purpose, absolutely. I think listing all the statutes, people aren't gonna understand that. You know, they're not gonna understand how to read that. That's why I thought, you know, within the districts, you know, explain it in, you know, in rank and file terms instead of in legalese. So that they clearly know, okay, I have a right to this information, you know?
But at least here, Pat, they know where to look for it, right? Right now, it's everywhere, so at least this way they know where in chapter law to look for it.
Yeah, I mean, I don't believe teachers or janitors or coaches are trained in rights of parents.
Right.
You know what I mean? So, you know, I know some states do training. I know Florida does, Texas. I know there are other, Alabama, Arizona, South Carolina. They train in this so that everybody knows. So if you're a certified coach, you're going to get certified NHIAA. You're going to be trained in what information you need to, when a parent asks you something, don't tell them it's none of my business. You're going to tell them by law. So at least knowing that, I think would help. You know, some sort of training for personnel. Now, my understanding, these are even, this also applies to people with EFAs?
Oh, with the EFAs?
Yeah, so,
Yes.
because the parent gets the money, but it's state money and used for the child.
Well, I think it applies to everything except for private schools. But private schools have their own contracts with parents.
So on page 2, school, when it says there are any school or entity that directly or indirectly receives state funds for education. So I took that as,
So a private school that has a student enrolled that's receiving
EFAs,
EFA
yeah.
funding,
It
would it
would.
include that?
Yeah, it would.
Well,
so,
we'll look into that, because that can be, I appreciate the interpretation. I'm not saying I disagree with you, but that money still, I know it goes to the school directly, but it's really on behalf of the child. I think when it says receiving funding, it might be, I mean, it could even apply if they got like grant money for, you know, building aid, even if it's a private school.
Right.
So we should probably clarify that and at least trying to
Okay,
figure out.
or transportation too, I guess some, I know at one time Manchester delivered to, private schools.
Yeah, they still do.
Yeah. And then,
That's a good point, Senator.
So even if, so just, it's my research assignment. So,
He gave you homework.
even, so one, does the EFA eligible student, does it apply? And two, any other funding that that private school may get, whether it's a federal grant or state grant for, whatever it is that they're doing with it, would that then invoke this? Because I guess the other option, you don't want them either declining an EFA student or declining, not taking advantage of grant money simply because they don't want this to apply, right?
Right.
That's not the intent of this.
Right.
yeah,
So,
yeah. So this would also apply to homeschooling.
Well, for homeschooling, parents are going to tell themselves.
Well, two parents, but in a divorce, there's more issues with a divorced family. Even though there's a lot of them that work well with each other, their priority is the child. But again, there's avenues with which, how do I file a case with my ex? On either way, so I'm wondering, if whoever's homeschooling, do I have to give one of these to my ex?
and why do you believe that homeschooling would apply in this? I'm not saying it doesn't. I'm just-
Because they're receiving indirect state funds for education.
So again, would that extend to homeschooling? A lot of interest groups on that, they weren't here for that.
Yeah, I was surprised that,
We
yeah.
could- we could-
No, because I could have, because yeah,
That would have been a great question for them, but they're not here. But that's, okay. I'll add that to this research assignment's getting pretty heavy now. Is there any, I know there was some talk about adding mental health to this. I looked at, in here, it says medical treatment already.
Right.
right.
So I kind of looked at that as that, there's some RSAs, I would probably need to cross-reference those, but assuming those RSAs don't exempt the mental health treatment, if we're
Well-
going to include medical treatment, we can just clarify that including mental health treatment.
Yeah, because we currently, if a child is 13 or over having mental health care, they can get it without having their medical records given to the parents, so it would have to be in there.
So that would be a privacy for the child. But this
But
asks,
I think there's also a bill in the House that's going to try to address that.
So I was talking about page 4, lines 11 to 13. It says, any medical procedure or treatment to be performed on child, except, and it lists 2 RSAs, so I'm obviously going to look at those, but
Right.
assuming those are not relevant to the mental health treatment, I'm just
Right.
asking, including mental health treatment
Yeah.
in this. And I think in this case, it's that school is providing the mental health treatment. I think if they're going to an outside counselor or psychologist, psychiatrist outside the school, that's not what this is talking about. If the school is going to provide the mental health evaluation, that's when this would get invoked. I thought it would already fall under here. It says mental health treatment is medical treatment, if you ask me, but I think,
They're
Yeah.
billed differently, so
Yeah.
they're also protected differently.
I understand. So
Yeah.
that's probably why we want to
Yeah.
distinguish the two. I don't think that's an easy fix. It's-
right.
Yeah.
Yeah, one of the testimonies was clear that they didn't tell her, which was
Well, yeah,
wrong.
and so I'll tell you, when Seamus was still in elementary school, we got a letter that came home one day that said, if your child tells you that they were taken, it wasn't directed at him, like we all got it, is taken out of class, we met with a team, just so you know, that's a psychiatrist, it's like we're having trouble, and so we're bringing them in with a team, and I was like, I want to know before, like, if something's going on that's so severe with my child that they have to meet with this team with a psychologist, like, I want to be informed ahead of time to be
Right.
part of the conversation, right? So they're putting out these blanket things that are really keeping parents in the dark. And a lot of the things that parents don't understand is when you sign up your child for kindergarten and you sign they can go for screening. A lot of people think it's the ear and the eye screening, right? It's anything that they want to do. So that's why it's really important to make sure that that's in there.
In respect to the freedom of speech concern raised, I think that's,
Yeah, I don't think that's,
I don't think that's vague.
we're not taking any disciplinary
Yeah.
control.
I mean, this bill gives, confirms privacy for minors, twice. Fundamental rights, like on the first page, starts at 27, 28. Fundamental rights of the child included in the right to privacy. These are all child rights. Privacy, freedom of religion, freedom of association, freedom of speech, and also on page 4, page 14, starts at 14, they also enjoy the fundamental rights of religion, speech, privacy, due process, freedom of association. So this is codifying, in my opinion, twice the rights of children. And then on page 4, number 34, required disclosure, well, nothing in this chapter shall require disclosure of information provided to any counselor, school psychologist, school nurse, or other certified health care provider where the information provided was reasonably expected to be confidential. I think counselors and psychologists are reasonably expected to be confidential.
I think psychologist, school nurse, I'm not sure if all counselors rise to,
Right.
meaning like, I'm not sure that there, I would have to check, is there anything in the law that, is there a privilege or that exists already? If there's a privilege,
Okay.
you generally would presume it's confidential.
Right. So again, being a worker of any district, I don't know what would be reasonably expected to be confidential, and that's what we're asking them.
So when I've seen that language, it usually applies when there's already some type of protection of that information in the law. So if you have, let's say, like an attorney-client privilege, right?
Right.
I mean, obviously, there's not an attorney representing the child in the school that works for the school. But for the sake of that, when you talk, if a child speaks to the attorney, I think there's an expectation of confidentiality there because of it's protected. So the same would apply to a doctor if the child reaches a certain age. So there's an expectation of that if the doctor works for the school directly. But what we're saying is, in this case, I understand where you may see the conflict. There wouldn't be a reasonable expectation of privacy because the law is saying there isn't. So
Okay.
normally when you have, this is the practice, this means followed. If something is confidential or not, usually that person explains to the person, anything we talk about is confidential. Right? I have parents that sometimes pay the legal fees for, a child, which is great because, someone's paying the bill, right?
Right.
But I always have to remind that parent that, they're not the client, number one. And number two, when I talk privately with the client, I can't share that. And sometimes they get upset, but that's it. It's the child's privilege to waive, but if they promise they waive the privilege and tell their parents, they also waive it with me. And then
Right.
that messes up the whole thing. So there's an expectation there. I think if the law says this won't be confidential, I would assume that once this is implemented, the psychiatrists, the nurses, they would know that. But I think, for example, we talked about some of the medical stuff, like the sexually transmitted disease, substance abuse, that stuff.
Right,
Because if there is an exemption for that, there's a reasonable expectation there.
right.
So
I get that. Yeah,
that's a real technical reading of it. I'm not,
yeah, no, I could see where I could read
you may
that
want to
way.
vet that with someone
No,
else.
yeah,
That's my interpretation, but I think it's a lot for a child to understand that, so I think the best practice would be for them to disclose what is and is not confidential. Same thing with as a mandated reporter. If they report abuse to the school nurse or to the psychiatrist or psychologist, that's not reasonably, that's not a reasonable belief that will be kept private. They're a mandated reporter. Same thing, they would have to disclose
Right.
it.
and then on page 5, the reporting, if the school personnel shall immediately notify his or her superior. So I'm an English teacher, I would notify the superior of English, that the person that oversees the English department? I mean,
I'm sorry, Senator, what line are you on?
on page 5, line 16.
Okay.
I mean, I'm just looking, and then the district gets sued, and the superintendent or the attorney for the superintendent says, yeah, I didn't get the information. You know, it's the English supervisor that was this supervisor who got the written report. Yeah, I don't know, just to make sure it gets up to the level where it should be getting up to, that it shall immediately notify his or her superior. It ought to be the person that runs the school, or an assistant,
I think it would be
assistant superintendent or superintendent.
I think it should, so it could, yeah, I think, well, so some towns are smaller, right? So if you went to superintendent, it may not be as dramatic.
Oh, I see.
Salem
Yeah,
has,
yeah.
5 elementary schools, a middle school and a high school. So I think going to the principal would, or if it's assistant principal, I don't think it's completely outlined, but I think, the principal would be the one you want them going to, right? Is that any problem with clarifying that?
I don't think so.
I think that's at least the intent.
Right,
I think the head of the English department, as you said, is not,
right.
you don't want that's kind of outside their purview of making that call.
But that would be their supervisor.
Technically,
Right.
yes. If there's a ranking, I see what you're saying, so we can clarify.
Appropriate administrator?
Yeah, it can be the principal or the.
Yeah, I think the
unless they want to
principal's fine.
designate someone specifically for this.
Yeah.
Or the designate.
Like in our elementary schools, that's the assistant principal usually handles disciplinary actions and this
Right.
kind of thing on this level. So it would be whatever is deemed the appropriate administrator.
So the principal can decide, I want the assistant principal to handle all of these, and that would be
Yeah.
this one.
Yeah. I think that was it.
Am I right to assume that we're all in favor of this? We just have to work on it a bit?
Well, I'm still concerned about the divorced parents and the clear and convincing evidence and the training.
So the divorced parents thing, we can't resolve that in this, if there's a, in that agreement or the judgment or whatever decree stating who has access to what, who gets to make what decision. I've seen them where it said, parents should do their best to agree, but if they don't agree,
Right.
this parent gets to make the decision on extracurriculars. If it's spelled out that way, that's not, the school has no say over that. That's a judgment
That's
before.
right.
of-
Yeah, no,
They need to follow, that's all they
yeah,
can do.
well, I mean, the school personnel cannot keep anything confidential. That one of the parents said, if my ex finds out he's playing football,
I may not like it, but it's too, they have a judgment
No,
saying they
no,
can make the call. Yeah.
They have to make the call, that's correct.
Yeah.
Yeah, that's anything.
So the clear and convincing one, we can keep discussing that. At least I understand that, you know, I'm not sure it creates confusion, but I understand perhaps if we change that. You had a concern about the evidentiary standard, the divorced parents, what was the third one?
Training.
So,
I mean, I don't know what we do, but I would, there's no training whatsoever currently for school personnel, a janitor, a coach, a teacher, administrator, on any of this. And from what Senator Lang said, just put the statutes in. I thought it was going to be, well, I would ask the Manchester School District to interpret it where it's understandable. It's not legalese. So every parent gets this, okay, these are my rights.
So, yeah, but so there'll also be, it'll go to rules too, right? So there'll be rules around this that the Department of Education puts out. That will clarify.
Oh, there is?
There's always rules for education bills.
so in regards to the training, if, you know, you gotta trust that the school is gonna provide the appropriate training. If they choose not to, and there's violations all over the place, I mean, I think that's the school's fault for not providing the staff adequately training. I mean, that,
You would think that communication with parents is already something that they train, they discuss, and they have guidelines around, right?
so,
Yeah, well, from what we heard in testimony, it's not in every school that's doing that.
but mandating a training curriculum, I think is not, that might be going too broad, because,
And then we have to fund it.
well, we would have to, we should fund it if we're gonna mandate it.
Right,
but
that's what I'm saying.
But I'm also looking at this as, you know, usually when you have a training requirement, there's some curriculum or guidelines what the training is.
Yeah. Yeah, there
Especially
are,
since
there
most
are
of this is in
states.
statute, so they should already know the bulk of this.
Yeah, but we're hearing testimony that they don't, and that's the reason for this bill, is to make it clear.
I think that they claim they don't know. I didn't know I couldn't do that. I mean, some of the stuff to me is blatantly straightforward. All right, it has nothing to do with having a legal background. I think for the most part it is. It references RSAs. Now, I do have a concern if the school wants to, you know, try to interpret some of these and rewrite them a different way. The problem is they have to make sure they're interpreting it correctly, or they're not deviating from what its intended purpose is. That could create a conflict. So I think they can put the RSAs in there, like Senator Lynn said, and if they want to add some clarification there. But if a teacher looks at that, or a school personnel looks at that and doesn't understand something, I would hope being the operative word, they would say they don't understand this. Can you give me some, you know, someone asked me for an example. There's nothing wrong with that, right? That's what should happen.
No,
That's what you hope happens.
Yeah. I mean, you know, the general court is establishing a parental bill of rights in education, and we're telling each district or entity that has to follow this to come up with your own, you know, training or, I don't know if I would think that one of these states would have an idea of what they trained them in, right? You know, we could probably look there first. But leaving it up to each individual district or, you know, EFA school, it would be all over.
I just look at the list of, you know, topics that would fall under this, and is there one in there that I guess jumps out that would, I know when it comes to like some of the medical information, stuff like that, I think they're already getting that, aren't they? I may be wrong, but I'm talking about new training. I'm just wondering where that would,
That's what I'm saying. Most of this is already in law, so they should already be up to speed on it.
I also think it's very straight, a lot of it's very straightforward. I mean,
Yeah, but I don't know if the personnel, the workers of these districts haven't been trained in this. You know, they don't know these. You know, as an English teacher, I'm having conversations with parents. If somebody was gonna say, hey, you know, I asked you if, you know, if my son was hanging around with these other kids that were stealing out of lockers. You know, you know, I don't know about that. I don't know that.
Whatever.
So you know, I don't know, I don't know, I'll ask any teacher, can you explain to me these rights? And I think we're gonna have a difficult time. I mean, you ask a school district lawyer, and they're gonna say, yeah, I can explain to you these rights.
I'll just pick the random one. So on lines page 3, lines 19 to 20. It's letter J. The right to opt out of health or sex education or any other objectionable material as set forth in RSA 186:11, and it lists other sections.
Yeah,
So-
yeah, something like that. I agree with you there.
It's pretty straightforward.
Right.
It does reference an RSA, so
Yeah.
if a teacher, I mean, if you literally Google that, they're gonna see the listed sections. So, I mean, having a training on that, I suppose could, you know,
Well, they would need a training on that. That is a simple one that I would think teachers would know that. I don't want my child in your sex education. I think a teacher would get that. Yeah, that's fine. That's what you can do.
well, there'll be more to talk about this. The reason why we're doing this, because I know once this meeting ends, where that wall goes up and I.
No, right.
I feel-
Yeah, those,
I don't wanna
yeah,
do-
those,
I'm not saying I like that, but, you know, so I'm giving you the time. I guess if any of these, you don't have to answer this now, but if any of these sections you think would require some type of specialized training, you know, I'll be interested to, you know, look
Yeah.
into that.
well, you know, the intent, from what I understand of the bill, was to make it clear of parental rights, to make it clear to the entities, the school districts, that there are parental rights. And I don't know if any district has a course in that, or has a, you know, has a day where they sit and talk about all the parental rights, you know?
But let's say we're in front of a school system right now with all the teachers, and we went through this. I'm just saying, do they need training on this? Other than we have to, I don't mean this, they're not spoon feeding this.
Well, they do, they need to know what's, you know, you know, they need to know what's clear and convincing.
So aren't they updated annually as to what the new laws are that pertain to education?
So
Isn't that part of the professional development each year, is to go over the new laws that are pertaining to education?
Yeah, I don't know if they do that, they may. They may do that. You know, all I know is that 1, 2, 3, 4, 5, 6, 7 states did a training. You know, I like the idea because it's a state initiative, and let's be on the same page. Don't give, you know, not many districts there are in New Hampshire, their own spin on stuff. You know,
So-
we're consistent.
If the bill doesn't expressly say that there is rulemaking authority, that there needs to be rulemaking authority by the DOE, then it won't make the rules. So should we put that in the bill? And that way, it'll be a clear outline going to the schools.
Yeah, that would be helpful.
Would that be good?
Yeah.
You may support a potential amendment, but not the whole thing.
Well,
Do you want
yeah,
to put in the amendment? Senator Long?
an amendment as far as the training?
Add rulemaking authority
And-
for the DOE.
And Senator Long, even if you ultimately don't support this, I do appreciate the.
I really do too.
Because I'm the same way, right? I may not support something, but I still offer, well, it should say this, not that.
Right. Well, you know,
I do appreciate
the
it.
declaration of purpose is, I don't have, the only issue I have is with divorced parents, but, you know, because it mentions parent or parents. And that's what flagged me as too. You know, we're not
I don't know if there's. a way-
dealing with a parent per family. You may be dealing with two parents.
You could be dealing with 4.
True, yeah.
Oh, boy.
But, yeah, you know, I have no issue with the declaration of purpose. And I get the gist of this, which I agree with. Holding back information for whatever reason from a parent, I don't agree with.
I don't think we can solve the divorced parents issue.
We
I don't-
can't.
No, I get that.
Which,
But I mean, the trusted adult thing, I agree. First of all, if I'm a coach, some kid comes up to me telling me, hey, I'm sick and tired of my mom and dad, they're drinking and drugging all night, and I'm like, yeah, don't tell me.
Well, yeah, but then now you've got a duty to report because that child's in a potentially abusive or neglected
No,
home, right?
and I would.
But it's also only if the parent asks you. Like, it's not saying that every time a child talks to a teacher, that teacher has to run to the parent. But if the parent comes to the teacher and says, hey, I'm noticing something going on with my child, is this behavior happening in school as well? And they say, yeah, actually, I've seen a couple of things. Now you have a team around that child to
Well,
talk
how
to.
about if I ask, do you know if it's happening at his father's house?
But the teacher wouldn't have that information.
If the kid told me, I'm tired of my dad, when I go over my dad's, he's drinking and drugging.
Again, has a responsibility to report.
Yeah, it has a responsibility to report. However, I have to tell the parent, because I know of that,
Right.
because the child told me, because I'm a trusted adult of the child, I have to tell the other parent that, yes, Johnny told me that when he's at his dad's, he's drinking and
So
drugging.
if that was, I think we're getting in the weeds now, but if that wasn't the case, wouldn't that child be better off by the other parent knowing now so they could put them in a safe place and not have them go to the other parent's house?
Yeah, but what happens to Johnny that told his teacher that from his father?
The teacher has to report to the parent.
Yeah, and Johnny's upset.
Johnny can be upset.
but they're
Well,
Kids get upset.
Johnny's a child that's not gonna have, the trusted adults is an issue here. I think that's an important,
They're already a mandated reporter though, so that's, and then if
Right.
there is an ECF investigation, the other parent's in the know either way. So, you know, that scenario, the parent's gonna find out eventually, but I think if that teacher is the mandated reporter, I think in that case, they don't have to disclose that they would have reported. Their identity is gonna stay confidential.
Right.
So I think that would fall under the exception, because they're not supposed to disclose that, the identity. Because they have a reason not to disclose it. Usually, sometimes they do their best in the reports to try to,
oh, because they're doing an investigation.
they do their best to try to hide that mandated reporter. Sometimes it's you can figure it out through logic, but even with that, so if they weren't the reporter, withholding the information would still not necessarily be appropriate if they didn't have to disclose it.
Right. But again, in divorces, how can I get at my ex?
Right.
That's a whole other thing for the courts. That's not gonna,
No, you're right, but you're not wrong, but again, we can't,
No, right.
I can't solve
I get
that.
that.
All right, any other discussion? I think this was a
No,
healthy use of our
Yeah.
compliance with 91A.
yeah.
So
The reason why I say that is, because there's only 3 members of the committee, if myself and Senator Long would have a private conversation on the phone, because it constitutes a quorum,
it's a quorum.
we can't do that, so you have to watch us make the sauce from scratch the whole way through. Yes, after the hearing, if you wish to speak to anyone, if they so want to, you can, that's each individual member's choice.
I'd like to make a motion to move out of executive session.
Second?
All those in favor?
Aye.
Aye.
All those opposed? All right, we now out of executive session, and we will adjourn the Children and Family Law Committee.
Thank you, gentlemen.